SJC-12746, Timothy Deal v. Massachusetts Parole Board.
Mr. Schnipper, good morning.
Good morning. May it please the court, I'm Merritt Schnipper for Timothy Deal. I'm joined here by Barbara Cabin, my co-counsel, who also represented Mr. Deal before the parole board. There are two related issues at the center of this case. The first is what it means for the parole board to take into account the particular attributes of youth that are relevant to juvenile punishment for purposes of this court's Diachenko 2 decision. And the second but related question is how can a reviewing court assess whether the board has done so, and what does the board need to show to allow a reviewing court to perform that necessary function?
You know, Attorney Schipper, I've been thinking about this because this comes up a lot in different contexts. How do we look at something based on another agency or another department or another court applying factors to
Sure.
something? And one thing that would help me understand how we could frame this is, can you articulate for me what you think the board should have said, and we could take it outside of this case. We
Sure.
can make it an imaginary defendant. But an imaginary defendant who committed a crime at 17, and then we've got the parole board looking, how do they articulate that nexus that you're looking for? What language are you looking for specifically?
I'm definitely looking for language that both recites in some level of detail the actual evidence relevant to Miller factors that was presented. So in this case, that would be the multiple risk needs assessments, the work and educational history, the programming history, the family factors, the community factors. So identifies those in some specific detail relevant to the individual case, because they're going to be different at each case. And then talks about the way the parole analysis that the parole board has to perform more generally under its statutory mandate is impacted by the fact that all this evidence arises in the context of someone who's subject to these particularities of youth that are so relevant to punishment: the neuropsychological development, the vulnerability to family and community influences, and the increased amenability to rehabilitation based on the fact that people are still growing and maturing into their own individual selves. In this case, it was quite notable, that as Mr. Deal showed them, basically he followed the trajectory that's pretty typical for juveniles convicted of serious offenses, which is that he hits adult prison as a teenager and is somewhat misbehaved, and around the time of his mid-20s completely steers the ship into a new direction that's purposeful, that's forward-looking, that's attempting to take advantages of all the opportunities he has to shape himself for a life outside the prison. So he presents a very significant amount of evidence to the board that's relevant to this, sort of sub-analysis within the overall parole decision. And the board really just is taking the position here, and I would say the record shows that its position was, it can simply say, well, we acknowledge that that evidence was presented. You did submit that to us, and it's here in the record that's collected for this court. But they don't choose to say anything about its character or about the way they weigh it in the overall determination of whether he's parole eligible, other than that they looked at it and took it into account.
So how much do they need to do? So it's important, it's constitutionally required, you've got to take into account the distinctive attributes of youth, and the board does so. What do they have to do to show that they did that analysis?
They have to identify the specific evidence that they interacted with. They have to explain how they believe it shows Mr. Deal is or is not ready for parole, and then they have to explain ultimately why they rejected it if they did. I mean, they basically have to allow a court to understand how they weighed the factors and how they applied the factors.
And how do they do that in a summary decision?
Well,
That's what the statute says, right? That they should be issuing a summary, they only have to issue a summary decision, right?
Sure. Well, let me just say that a summary decision doesn't necessarily need to be 4 pages. It could be 7 pages. In fact, the first round of Diachenko parole decisions were more like 7 or 8 pages, and they contained more individual analysis. So, the statute says summary, and the Constitution says meaningful opportunity for release. So to the extent that summary needs to be adjusted in a particular context that requires constitutionalized action, they need to give more detail. But it needn't be
But in your
a
view,
long discourse. I mean, it needs to say, here's all the evidence he presented, and even though he presented this evidence, and here's what this evidence says in terms of research, in terms of statistics, in terms of how likely an individual is to succeed on parole. And here's all that evidence, and notwithstanding that evidence, here is the reason that we think more more rehabilitation time in prison is needed. And to simply say, you're not there yet, go back and keep working on it, that's really not subject to any meaningful review by a
Counsel,
court.
can I ask you a question? In the decision of the board, it says, the board is of the opinion that Mr. Deal has not demonstrated a level of rehabilitative progress that would make his release compatible with the welfare of society. I'm sure you're very familiar with this. And then recommends more programming and specifically says criminal thinking and restorative justice, because I think my reading of their decision is they're highly concerned with his version of the events and how that's inconsistent with the evidence. So is that some kind of threshold that has to be crossed over before we even need to reach some of these other things for a juvenile or any defendant to really have an understanding of what they did and the motive for it?
Sure, well, I think I'm really glad you raised the issue because I agree that is primarily what the board relies on. And I think, when you look at the record, and I would specifically direct the court to pages 39 through 51 of the first volume of our appendix, which is where Mr. Deal spends his time at the testimony discussing the offense. He actually says a tremendous amount about his motivations and the reasons that the offense occurred. And he talks about the route he took into street crime, following an admired older brother, with interpersonal problems in his own life. A promising student goes off the rails. He then talks about how the ultimate murder victim in this case ends up in trouble with the law, ends up informing against him, and that all those actions formed a really sort of troubled subtext in their entire friend group that were bubbling below the surface. He talks about the night of the offense, and about how he doesn't understand how it came to this, but everything exploded to the surface. It started about something small, and it ends up with him stabbing somebody. So if the board is saying, well, you're not being frank about what you did because what you did is you went there with the intent to kill a person who had informed on you. Now, besides the fact that that simply may not be true, what the board is missing the opportunity to do, and what I would argue is required to do by Dyachenko, is to say, well, look, this is how you actually explain the night of the offense. Here's how it parallels with the research you presented to us about the way juveniles process conflict, about the way motives can often be inscrutable to young people who are behaving in highly tension-filled circumstances in ways that are intended to sort of save face. They don't really know why they're doing. A mature adult wouldn't engage in such behaviors. This is what Mr. Deal says. I look back now and I see that I was cowardly to stand and fight and to grab a weapon rather than to just understand we needed to walk away from this. He sees that now from the perspective of a matured adult. But what I'd like the board to do is, instead of saying you're not mature because you haven't agreed with what we say you did, I'd like them to say, and I think the Constitution requires them to say, this is why what you did say still leaves us concerned. And it may be a subtle difference, but it's really about engaging with the evidence that's presented, rather than saying that the board can simply say, well, we have a superstructure that you're going to need to fit into before you are going to be parole eligible. Now, that may be their discretion as to the ultimate parole eligibility analysis. But with regard to the decision about whether to provide a meaningful opportunity for release and what's necessary for them to do that, that is not within their purview. That's within the court's purview to outline the steps that they need to take consistent with the statutory structure that these young people are being sentenced under. Right, because the board has to take action that it's going to then provide to a reviewing court, so the reviewing court can understand in the first instance whether this sentence is actually being executed constitutionally. The board has to create a record that the court can use to understand the individualized decision making. I mean, Miller and Dyachenko are about the need for individualized sentencing.
What is the scope of the court's review?
Well, it's an abuse of discretion standard, but its scope, I would say, reaches every aspect of the evidence that's presented that's relevant to what we know as the Miller factors. So neuropsychological development, increased amenability to rehabilitation, community and family settings that are relevant to the commissions of crimes, and the likelihood that your crime is the product of environmental factors rather than individual failings. All these things are within the scope of the Superior
You
Court's
think that that's what we said in Dyachenko?
I do. I think what you said is that in order to actually make these, and you in your concurrence in the first Dyachenko said that in order to make sure that these sentences are actually constitutional as carried out, these individual factors actually need to be contemplated. It's not enough to simply say, well, we've got a big amalgam of potentially parole relevant evidence, and within it is some youth specific facts, right? There's a two-step procedure where the board has to say, here's a young person who was a juvenile at the time they received a mandatory life sentence, so we need to consider a whole set of specific things that they have brought to our attention when we can apply the overall statutory parole standard. So yeah, I think they do. I think it's pretty broad under Diachenko.
There's a separation of powers issue, though, isn't there?
Separation of powers issue is real, of course, because, I mean, it is ultimately the executive's decision about whether a person's paroled, but the executive's job is to execute sentences in accordance with standing laws, and the standing laws, in this case, are mandatory life sentences that this court has interpreted to only be constitutional if they contain both a meaningful opportunity for release and a robust opportunity for judicial review on this narrow but very constitutionally significant area. So the job that the legislature has done given to the executive to carry out is to produce a parole decision in the context of a juvenile homicide case that is susceptible to meaningful judicial review. So a court can come back and in the first instance say, wow, 15 years ago when this young person was sentenced to life in prison, actually their sentence was constitutional because when it came time for them to be considered for release, the relevant attributes of youth present in their case were actually considered. They weren't simply, acknowledged in boilerplate and then moved past because for whatever reason that, somewhat impenetrable to review, the parole board feels he wasn't ready yet. The parole board may feel he's not ready yet, and they may feel that for reasons that aren't youth specific. That's their discretion. But what's not their discretion is to basically just do a summary, or as the court said in Diachenko, a cursory analysis of the particular attributes of youth such that the only thing a reviewing court can do is say, well, board, we'll take your word for it.
Well, can you do more than that? So the Superior Court judge needs something to work with.
Yes.
For sure. But you've got the DA here at the hearing saying that really you can't reconcile your client's version with the evidence. And so they're saying, well, we considered the Miller factors, we considered that, but when we, can you interpret the decision notes? But you know what? Considering how important it is to accept responsibility and to understand the crime, his version of events indicates that he's not ready without more programming. Can the Superior Court judge get enough of that?
I think if the Superior Court judge is beginning with some sort of presumption in favor of the board's decision, he or she might be able to get there, but I don't think, so like you've got a person who's been in prison for 15 years. There's a record. You've got a 2-hour hearing before the board. There's a record. A thoughtful person can say, well, I can imagine why the board might have decided that notwithstanding X, Y, Z, this person still wasn't parole eligible. But the question is, does the Diachenko and Article 26 require more than imagining why and require a process that allows the judge to understand how? How was this evidence taken into account and what role did it play? The concern I have about the version of offense, the ADA statement, is that, first of all, it's not evidence. It's like it's a closing argument that's presented to the board, for conviction, basically. But what it doesn't do is it doesn't allow for the possibility that there's different perspectives on what happened, and that the perspective on what happened that's most relevant for the juvenile parole calculus is the way the crime itself and all the factors leading up to it were experienced by a young person in the midst of all these forces that these decisions say are relevant to juvenile punishment. So again, it's not, so presumably the board could say, look, this was a targeted killing of an informant, and until you admit that, you're not getting out of prison because that would mean that you're not rehabilitated. And I think we'd have a different case before this court, frankly, maybe even one that was easier for me to win if we did, because the bottom line is at some point, the court's gonna have to say, is the board's job to assess rehabilitation and the way youth factored in, or is the board's job to bend the prisoner to the board's will such that then we can decide, now, you're telling us what we need to hear, thus you're rehabilitated. It's a thorny issue because rehabilitation ultimately is their question, but the specific attributes of youth are the court's question. And unless the board can explain why accepting its version of events and not basically explaining his own experience indicates a lack of rehabilitation, I don't think they've done that here. I don't think a reviewing court can accept that. They need to understand how the board actually processed the information that's most relevant to its decision.
Are you asking for a new hearing, or are you asking only for a new set of findings?
I do think we're entitled to a new hearing, because I think that's what Diachenko says the remedy is for a decision that fails to take these attributes into account, or does so only in a cursory way. I mean, as a practical matter, Mr. Deal's next hearing is in December of 2020, so given the decision timeframe and how long it takes to get onto the list once you are ordered a new hearing, in this case, those would be relatively the same. But the point here has to be that, I mean, I think at this point, because once you've got a record and an SJC decision about it, I'm sure they can go back and write something that would satisfy judicial review at that point. But the point is, if you go back and actually take them into account in real time and produce a decision, then I think it's much more likely that that's going to reflect the actual deliberative process of the board.
But if your point is that we need a record that permits a judge to do a meaningful review as to whether there's an abuse of discretion, why would there be a need for a new hearing as opposed to new findings?
All right, fair enough. I mean, I suppose new findings, but I mean, those findings would need to be, you know, we've argued significantly about the record that would allow these findings, and it's very difficult to see where the board is coming from.
All right, thank you.
Thank you.
Mr. Landry.
Good morning. May it please the court. My name is Assistant Attorney General Matthew Landry for the Parole Board. Timothy Deal received a meaningful opportunity to obtain release, but he was unable to demonstrate the needed maturity and rehabilitation. The board appropriately took Deal's juvenile status into account when it rendered that decision. Diachenko, too, defined what the standard of review for certiorari actions, such as this one, should be. The courts ask one question: did the board properly consider or take into account the distinctive attributes of youth that were outlined in Miller and Diachenko 1? If the answer to that question is yes, the decision must be upheld. And this decision here sufficiently meets that standard. The decision in this case, it states the evidence that the board had before it. It correctly states the factors that the board used to reach the decision. And I think most importantly, it centers on the right question. It asks, was Deal rehabilitated? This is not a decision that is based on suspect or justifications such as deterrence or even just raw punishment. This decision is focused very specifically and centrally on the rehabilitation question.
Let me ask you, if the board had said this was a killing that was done because somebody snitched, and we want to send a message that if you kill for that purpose, then you should not get released your first time on parole, would that be, which was essentially what the DA argued, would that be a permissible grounds to say no?
In the case of a juvenile homicide offender, I think Diachenko 1 and Miller are quite clear that that sort of justification has a diminished role and would not be a proper central focus of a parole decision.
So the ADA's argument essentially should be viewed as irrelevant.
Yeah, in large part, that part of the argument, yeah, the board did not adopt that argument as its reasons for denying parole.
How do we know that?
Because
I know there was no reference made, but we also know that they use the same boilerplate they use in all their decisions, so it becomes a little bit hard to know what they really did when all they're using is boilerplate.
well, we know the board didn't adopt the ADA's suggested reason for denying parole because the affirmative reasons that they did give in the decision focus on rehabilitation. They say overall that he's not ready, and they talk about the fact that his version of the offense isn't plausible, and they talk about the fact that he needs more programming. And they also give him a 4-year setback, which is shorter than the maximum. It's still a long time, but that does suggest that they view him as potentially ready for release in a shorter than at that period of time. You know, the idea being that if he goes and implements these recommendations, you know, he stands at least a theoretical chance of getting parole in 4 years. So if this had been some decision that was designed to send a message, you wouldn't be looking for a less than maximum setback. You wouldn't be looking for, you know, specific courses to take, things like that. So I think the focus of the decision really is rehabilitation. Now, as to the boilerplate, I mean, the Deal's brief uses that term a lot. I think it's actually an unfair characterization of the board's decision. And I understand that there are these other 44 decisions that the amicus has introduced. So we have to look at each board decision as a whole. And the decision in every one of those 44 decisions, and then this one additionally, it has the lengthiest section is the one where it individually discusses the evidence that was presented in that case. And I think a lot of what the board does, a lot of the board's thinking is woven into that section. And when you get to the section of the decision that's under the heading decision, a lot of that language is reused because they're just stating what the factors are. And of course, those are the same in every juvenile case. So at that point, I think the board is doing a lot, some of its work, at least showing some of its work in the earlier part of the decision where it does discuss the individual evidence pertaining to that person's case. And then says, taking that evidence, here are the factors we apply, and then after having done so, we conclude the person's not ready for the reasons that it gives. But I wouldn't at all characterize it as boilerplate. That's akin to a standard of review section, I think.
So, I mean, I'm looking at it from the point of view that constitutionally, Mr. Deal was entitled to a review by a judge for abuse of discretion, and also a review to determine whether or not the Miller factors were considered in more than a cursory way. So I'm trying to figure out what we say to the parole board to say this is what you need to do in order to allow a Superior Court judge to be able to conduct that type of review.
I think that the hallmarks of a parole board decision in a juvenile case, it needs to state what the evidence that it heard. It needs to explain the factors correctly, and it needs to be focused on demonstrated maturity and rehabilitation, just more fundamentally. I think if we do that, if we have a parole board decision that is focused on the right areas, I think we can be more confident in taking the representation that the board makes, that they considered certain evidence. We can be more confident that that's not a cursory consideration. I mean, if we had the case that Chief Justice Gantz, you just mentioned a minute ago, where instead of saying what they did say, they said that serious crime, we think that he deserves longer time in prison, we deny parole, but that same sentence that we considered evidence is in there, then I think you have a case where we might wonder whether that's a cursory consideration, right?
What did they say here? I mean, I understand they said, we considered these factors. They don't analyze them individually. I mean, they didn't say that they're applying the snitch rule that the prosecutor argued for. It seems to me all they said was he needs to be more mature. He hasn't really accepted responsibility. Is that essentially what they did here?
I think they said more than that. I mean,
They really? It didn't seem. What more did they say than that?
Well, the decision.
And by the way, I'm not sure that's not enough, but to me, when I read this, it doesn't say he was punished for being the snitch thing, but he hasn't grown up and accepted responsibility as demonstrated by his explanation of what he did, which is not plausible. Did they do anything more than that? I'm just curious if I missed anything in what they did beyond that.
I think the more piece of that, when they talk about the two specific courses that they needed him to take, restorative justice and criminal thinking, I think it was. When we reference to the record on that, there's a specific part of the hearing where they talk about those two courses specifically. And when we read the hearing transcript, we sort of figure out where that comes from. So 2 months before his parole hearing, Mr. Deal had appeared before a 3-person panel of Department of Corrections officials, and that panel had concluded that he was still minimizing not only the crime, but also his earlier disciplinary issues in prison. So the board is approaching this, seeing a person sitting before it that just 2 months ago was apparently still minimizing, and they ask him about that. And in the course of that interchange, one board member says, well, there are these two the specific names, these courses that may help you address some of these issues. And so when
criminal thinking and restorative justice.
Right.
And I read the editorial in the newspaper today, so I have a sense of what restorative justice is, but I don't know what is criminal thinking? What is that about?
I don't have a real deep working knowledge of what that course is, but I imagine it would be designed to address sort of the attitudes that cause you to commit crimes and overcoming those, and certainly in the context of a person that appeared to have been minimizing his responsibility.
So that additional sentence provides additional reasoning in your view. Yeah.
It does. That's almost a separate issue than the version of the offense. That's going to his recent minimization of not only the offense itself, but also his earlier disciplinary issues within prison.
Is there any obligation to address the experts' conclusions?
Not in the specific detail that Mr. Deal wants.
But I guess it wasn't even addressed at all, is the problem here. They didn't say, we don't find him credible, they didn't confront any of his analysis.
I think the inference that's required is that they didn't credit it because they did credit competing evidence that he wasn't rehabilitated. I think that's what we have at this decision. I certainly wish there was a few more sentences about why, but I also don't think that the absence of that dooms the decision. I think it's an obvious inference that they didn't credit Dr. Packer's report because Dr. Packer was saying, among other things, that Dr. Packer didn't think he was minimizing, and the board found that he was, based on other evidence. So I think that certainly if the board's going to rely on evidence in its decision to deny parole, I think it needs to explain that, and it did. But if they don't have to necessarily discuss, at least under the current standard, with detail why they didn't credit other evidence in the record.
And Mr. Schnipper says that the DOC's own personalized program plan rated his risk of recidivism as low. Is that true, by the way? I didn't go back to the record.
I didn't see that report in the record, so I can't speak to that.
Okay, so I guess, I mean, the issue for us is to recognize that the parole board is we don't expect them to write 400-page decisions. But with SORB, when somebody has an expert, we sort of expect them to confront the expert testimony. And when and the question is, what do you need? And I understand that it's perfectly fine to establish what the standard is as set forth in Diachenko and other cases and have boilerplate for that. But in most judicial decisions, you would identify that and then you would go on to do your analysis. You wouldn't sort of say, that's the standard, the answer is no. What guidance do we give to parole to enable, to require some degree of rigor by them, some degree of adherence to their obligations under Diachenko, and also enable a meaningful review of what they do?
I think the board has obviously an obligation to explain why it's chosen to deny parole, and it can't do that in a cursory way. It's got to set forth, it's got to give him some guidance as to what he needs to do differently next to get ready for release. And if the court chooses to say that it needs to address in more detail experts that are put forth, I think that's fair. Again, I think if this decision could have benefited from anything, it may have been from a few more sentences as to what they made of Dr. Packer. But again, under the existing standard, I think this decision, at least as we apply abuse of discretion right now, the board or agency doesn't have to discuss every single factor, every single piece of evidence, even material evidence, with specificity. So I guess where I'm going is I'd ask if the court is going to impose that requirement on future decisions, that it affirm this one first, and then maybe set forth.
Are those factors
prospective
emblematic
guidance.
of maturity? I mean, the factors overlap, right? They're basically, okay, children, young adults are going to evolve, but is that what they need a summary decision explaining why they don't think the person has matured, or why the opposite, it was a product of immaturity that's gone beyond? I'm just not sure where we're going with this. Once you go down the road of every factor, it doesn't sound like we're talking about a summary decision. And I'm not sure those factors, when you read the Diachenko itself, it's as exemplified. It backs into those factors. I understand Justice Lincoln or concurrence singled them out, but in the first Diachenko, but I'm not sure what it means. Why don't you take a crack at, if we don't have to do individual, we have to analyze something. What is it they have to do? I'm getting nervous that you're walking into every single factor, but I'm not sure that's what we meant to say.
I think the way I read Miller and Diachenko is the most fundamental, the core holding of Miller and Diatchenko is that juveniles are different, and that whereas one might permissibly be able to say, an adult who committed a serious offense, that, that serious past behavior is indicative of future reoffense. Like, there's a correlation in adult cases that I read Miller and Diatchenko as saying fundamentally that doesn't hold in juvenile cases. And I think that is the state of mind that the board needs to have. It's more of a fundamental principle than it is, these specific factors. And I think the fact that the board hasn't discussed each one of those factors in its decision, it's almost not relevant because, well, it's not relevant because the real issue is it makes sure Miller and Diatchenko want us to make sure that we're focusing on demonstrated maturity and rehabilitation. And I think if the board approaches that inquiry, if they say, is the person rehabilitated, as opposed to making these other inquiries about punishment, about deterrence, about incapacitation, those things that Diatchenko say really have to take a secondary role, if any at all, in these cases.
So did they do that? Back to the so did they do that here?
Absolutely. The fundamental decision here is right. It's based on the board is thinking the right way with this decision.
The principle is this crime could have been a product of, okay, his brother had a lot of influence over him, and kids his age are susceptible to that, but he hasn't demonstrated what. I'm just trying to, it seems like the fundamental principle they're supposed to analyze is whether this 28-year-old or 32-year-old is now mature. And the board seems to have found he's not mature without a lot of explanation. But is that what they need to do? They just need to flesh out this maturity point as opposed to breaking down 7 different factors which are interrelated and in many ways inseparable.
Right. If the board explains its fundamental reason for denying parole, if they say we don't find you rehabilitated because we don't believe your version of the offense, or we think you're not taking responsibility for the crime, or in another case where the prisoner has had more extensive disciplinary issues growing up in prison, or it does need to set forth that reasoning with at least enough detail so that a court that comes along later and looks at that is able to at least understand what the board was trying to do. And I think that's the fundamental principle of judicial review under Diatchenko 2 is the court needs to be able to understand what the board did, and it needs to understand that the board did in fact consider the Miller factors. And I think as long as the court is able to at least discern what the board did and that it considered these factors or considered the decision based on rehabilitation, I think the decision must be upheld.
Do they have to say anything more than what the board considered all factors relevant to Diatchenko decision in making this determination? Is that enough without saying how they applied these circumstances to the standard?
If that was the only sentence in the decision, that wouldn't be enough. I mean, this decision sets forth the evidence that was introduced at the hearing, and a lot of that evidence ties specifically to his youth and his upbringing and his development in prison. I think that sort of language that's in this decision is helpful and necessary.
One final question. He was found guilty of second degree, not of premeditation. Is it permissible for the parole board to say we're not going to release him unless he admits that he premeditated the crime and walked into that house knowing that he was going to kill him because he was a snitch?
I think the board could say that the board is allowed to look at the trial evidence and say, we think by preponderance that this suggests a premeditated murder. I want to be clear, I don't think that's the grounds on which this offense was found to be implausible. I think when the forensic evidence alone suggested that this was something different than what Deal was saying that it was. He's asked questions at the hearing about, well, you're saying this is all an accidental fight. Well, then, how is there a 4.5-inch deep wound in the victim's back? And his answer is basically, my eyes were closed, I was swinging blindly, and I might have caught him in the back. The version fundamentally wasn't even consistent with the forensic evidence, and it was internally inconsistent within the hearing itself. Like his version within the version itself was inconsistent with other things that he had said during the hearing.
But it's I think it's pretty troubling for you to think about being able to go back to the record and say somebody who's found guilty of murder too, in fact, on a preponderance, is really, we should consider that as murder one. I mean, that's pretty troubling, don't you think?
I don't think the board has,
Now, I'm not saying it happened here, but I thought
Right.
you suggested it could happen, and that would be okay, and I'm not sure I think that's okay.
I'm not aware of a case in which that's happened, and I've read a great
But I mean,
majority.
basically changing the verdict to what it pleases.
No, I don't think so. I think a better way of saying what I was trying to say is that when the board is seeing the person sitting before it, it's got to make an assessment of that person's credibility. When they ask him what happened, tell us the facts of the crime, tell us what, honest and open and complete version, that person's going to give an answer, and going to answer those questions. And it is ultimately the board's job to just say whether they think that person is being credible. Just as a trial judge, anytime a witness is on the stand, or a fact finder will do any time that they have to confront a witness. I think that's a better way of saying what I was trying to say.
All right, thank you.
Thank you.